Welcome to Ground Rules, employment law over your coffee break. My name's Pam Howland, and I'm here today with Jennifer Walrath and Doug Plass, who are also attorneys with Idaho Employment Lawyers. Today we're talking about navigating mental health in the workplace. And this is a topic that comes up frequently in our practice. We do a lot of Americans with Disabilities Act work. That I think might be our sweet spot. And I say that because we recognize that a lot of employers don't deal with ADA accommodations or the requirements under the ADA on a day-to-day basis. And when you don't deal with it frequently, it makes it hard to know it and to understand it well enough to maneuver through it. We, on the other hand, do get enough inquiries under the ADA that we're pretty comfortable with the process. We've had a number of ADA lawsuits we've defended, even more Idaho Human Rights Commission complaints that we've defended. So we feel pretty good about the obligations imposed upon employers by the ADA. Mental health is one area under the ADA that is what I would call a frequent flyer. It's a topic that causes a lot of confusion and questions with employers, and it's somewhat of a new and evolving topic that I feel like has really developed, and we've had more case law and more analysis over it over the past few years. So we want to talk a little bit about that with you today. And the first issue that I would say employers need to be thinking about is really the scope of the ADA. If you've ever heard us talk or present on the ADA, you're going to hear us talk about the importance of knowing it well enough to spot issues. And that principle applies when we're talking about mental health in the ADA. So let's talk a little bit about what that might look like. One area that is clearly covered by the ADA is depression. So that is one area related to mental health employers should be thinking about. If you had an employee approach you who said, I suffer depression, or I'm getting counseling, or I'm on a prescription drug for my mental health condition, those are all things that could trigger some type of notice on your part under the ADA. Those are pretty common occurrences, right? There's a lot of people who suffer depression. The other thing that I think makes it somewhat difficult is the spectrum, right? Like there's you can have severe depression and then everything in between as far as how much someone's mental health condition is impacting them on a day-to-day basis. So that's another tricky issue that I think trips employers up sometimes when it comes to spotting issues under the ADA. Don't discount depression as being such a common condition that you might think is not covered, because depression is clearly covered under the ADA if it's impacting an employer's ability to do their job. Stress and anxiety, likewise, those are conditions that if they're impacting an employee's ability to do their job, those may well be covered by the ADA too. So depression, stress, anxiety, PTSD, bipolar. How about ADHD? Yes, ADHD also a covered condition under the ADA if it impacts an employer's ability to do their job. So very important, as always, that your supervisors and the people who are on the front line dealing with your employees know that if they have an employee saying they're having trouble performing their job because of one of these mental health conditions, that somebody somewhere is flagging this as an ADA issue that requires additional time and attention. So what happens if someone comes forward with a request for an accommodation because of a mental health condition, or they tell you something that puts you on notice that they're having trouble doing their job because of a mental health condition. Let's talk a little bit about some important steps for employers to take if an issue like this comes up. So I'm going to turn it over to Doug, and he's going to talk about that a little bit more.
Yeah, thanks, Pam. So first step, I guess, and I guess we're kind of assuming this one is determine whether or not the ADA applies to your business. So if you have more than 5 employees, either the ADA or the ID or the Human Rights Act, the ADA through the Human Rights Act would apply to your business. And in the situation you just described, if the employee has requested an accommodation and it's a simple accommodation that you're prepared to just grant, um, you can go ahead and do that, and you probably should, and document that. But the first step really is to open a file. So you're going to want to open an ADA file. This is not part of the employee's regular personnel file. This is somewhere that is kept separate from that. Um, get that going, get the process going, and you're going to want to communicate with that employee supervisor and figure out either through job descriptions or or through some other means what the essential functions of that employee's position are. And then you are going to provide that employee with a letter that they can give to their medical provider that describes what the essential functions are and ask whether the employee can perform the essential functions of the position and whether there are accommodations that are necessary for that employee to do so. Um, I'm not sure how far we want to go here. Um, and then you're going to want to wait until you get that information back before you go any further. Sometimes this step is a bit daunting in that the employee isn't able to get it back when they're supposed to get it back, and you have to do a little back and forth to figure out how long you can extend that and at what point you're going to cut it off. But you really don't want to act until you get that information from the employer's medical provider. But then after you do, you're going to want to meet with that employee and talk about reasonable accommodations. There may be some accommodations that are proposed by the employee or by the employee's medical provider. There may be others that the employer is considering that will be equally as effective. And the employer doesn't have the obligation to accept just the employee's accommodation that's suggested if there are other ones that may work better for the employer. It's going to be a big brainstorming process to figure out what all those are, access resources that you might need to do that. And then you're going to want to decide whether or not to grant or deny that request. And you're going to document every step along the way. You want to discuss this with the employee, send them some sort of communication that lets them know what your final decision is about the accommodations. And then you're going to want to follow up to make sure the accommodation is working or not, and to see what other steps you might need to take. And I don't know, is that it?
I was going to throw in a little thought. Doug kind of mentioned talking about an accommodation the employee might desire versus one that is also reasonable, but that may be easier for an employer. And an example that came to mind was you might have an employee who says, I have anxiety and being around a lot of people really makes that worse. So I want to work remotely at home. And the employer might say, well, but I also have this nice office. It's in a quiet corner where you could work. And, you have to go through all the steps that Doug was talking about to see if the healthcare provider agreed that that could be a reasonable accommodation and what that all looks like. But that's a scenario where potentially putting the employee in like their own office in a quiet spot might suffice to address the issue. And if it's important for the employer that the employee be in the workplace and not working remotely, that might well satisfy the requirements of the ADA and be a better solution all around.
Right. And in that example, there might be a situation where most of that employee's interaction with other people are in like one or two meetings that occur. And you might consider whether or not the employee even needs to be present at those meetings. So, yeah, there's always a lot of options and a lot of flexibility potentially that the employers have to figure out what's going to work best for their business. Because that's the goal here. The goal here is to figure out how the employee's disability can be accommodated, and how the employer's business can be supported.
So, a couple thoughts on some of Doug's comments. First of all, Doug is cheating because he has a checklist in front of him. We do recommend, I mean, really, there's no way that employers can remember all this stuff, right? We use checklists. You should use checklists too. And if you're listening to this, reach out to us. We'll give you our checklist. I think that would be fun for us to hear that there's people listening today. Sometimes when it's just us in the conference room, we're like, I wonder if anyone's going to listen to this. So if you want our checklist, reach out, we'll share it to you. But what's really important is that you've got it in front of you, just like you would have a termination checklist in front of you, hopefully, if you're going to terminate someone. But the ADA checklist walks you through the different steps you should take. You don't have to memorize all of this. Use a good checklist. Doug talked about knowing the essential functions of a job. Hopefully, you've got a job description. Under the ADA, even with mental health issues, you really need to know the employee's key essential functions, their main primary job duties. Very helpful to have a job description if you have an ADA issue that comes up. So, get one of those. If you got one, make sure it's updated, because an outdated one is not very helpful. In fact, that can kind of make the process more cumbersome than help. So keep that in mind. And then the last thing I'll say about Doug's comments, he was talking about use resources when it's brainstorming time to come up with possible accommodations. One of the best resources for that's called the Job Accommodation Network. It's a free online website. So if you're in an accommodation situation, just Google Job Accommodation Network. That will give you lots of possibilities as far as broken down by medical condition. Like how do you accommodate someone with bipolar? You type that in and it gives you options. So that is very helpful. Okay, so that's the big overview. Let's turn a little bit to a question that we see all the time, which is, what do you do if someone's mental health condition is impacting their performance and causing performance issues? We're going to talk about that, and then hopefully we're going to take it home a little bit with some mistakes that we see employers make, or some frequently asked questions on the ADA. So Jennifer, what do you think in terms of the intersection between disabilities related to mental health and performance problems?
Well, we heard Pam talking about earlier, kind of if you're an employer who's on notice that someone may be struggling with a mental health issue, that could trigger obligations to take some steps and start going through the process that Doug was talking about. And I think sometimes when an employer might first notice that could be with performance or conduct issues. So if you have maybe a longtime employee who's always performed very well and you notice suddenly a very steep drop in their performance at work, or maybe they're engaging in behavior that's violating policies and getting written up more than usual, anything like that, something unusual is happening. And maybe at the same time, you're aware they've been going to some kind of counseling, right? You're kind of smack dab in a situation where that may well be triggering obligations under the ADA. And I would say sometimes it's difficult for employers to recognize that, because they're very focused on this employee, we're focused on the performance problem, right? Because that's what you do if you're managing someone and supervising someone and they're performing poorly. You want to go and try and fix it, make it better, make the record that they've been, doing something that they shouldn't be doing or not performing up to snuff. So I think it's just something to keep in the back of the mind as an employer that, in certain circumstances, a performance issue or a conduct issue could be related to the ADA. And you may have to do something. Now, not always, right? And you do get to kind of, well, I would say this. If you're noticing performance issues and you're on notice that there could be also an ADA issue, you'd want to make the ask, right? You can always ask, is there anything that we can do to help, right? And maybe they would say, actually, yes, there is something. And then you can put them through the ADA interactive process, get the information, find out what, if any, functions are being impacted, and what, if anything, might need to be accommodated for that employee. If those accommodations have nothing to do with the performance or conduct issues, or if perhaps the employee says, actually, thanks for asking, but I don't need anything, then the employer most likely can proceed, in handling it as a typical, discipline, performance improvement type issue. But just to be very conscientious, like don't skip over that step, because if you have an employee whose performance drops, you terminate that employee, it may come out later that the performance issues actually were related to a disability, in particular mental health disability, which, are kind of not the easiest to see all the time. And you could find yourself having to deal with a claim that you terminated the employee because of their disability. So anytime that, there's a potential link essentially between a disability and performance or conduct issues, it is an area where employers are going to want to just try to, be thoughtful, think through things, and make sure they take the right steps to work through the process.
Yeah, good points. And don't forget that under the ADA, an employee doesn't always have to come to you and specifically ask for an accommodation before you're on notice of a potential disability that could require an accommodation. So what do I mean by that? Well, like what if you had an employee who told you that they were on a new medication because of their anxiety and it was impacting their work? I would say that that would put you on notice of the need to at least do what Jennifer said, which is say, okay, is there anything I can do to help? Do you need anything from us? Those are safe questions you can always ask. And then, of course, you're going to document you did that, right? So that it's clear you opened the door, even though the employee had not outright asked for an accommodation. So let's talk a little bit as we, think through mental health and the ADA on mistakes that we've seen employers make in regard to the ADA and, maybe some other, takeaways and practice pointers on mental health for employers. I guess one point that I would highlight, things that we see, we've had cases like this in the past. One thing employers can't do under the ADA is just make an assumption that if an employee has a medical condition impacting their job, that there are no accommodations available that would be reasonable. So just skipping the ADA altogether based on an assumption that there's no way you're going to be able to provide help or assistance for the employee. The ADA is pretty clear. You as an employer are obligated to engage in the interactive process. You're required to work through the process. And even if ultimately the answer is there's no reasonable accommodation, you still have to go through the process and brainstorm and work to see if there's some type of solution. So don't skip the process based on your conclusion early on that there's just going to be no way we can do this. That would possibly create liability under the ADA, so don't do that. So what's an example of that? I'm thinking about an employee who maybe does sales and they have a requirement to meet a quota every month. That's one of their essential functions. Their key duties is they're required to make so many sales per month. What if the employee came to you and said, I'm suffering depression. I need an accommodation, so I'm not working as much. There's no way I can meet the current quotas that are in place. That could be an example of a situation where it may be that there is no accommodation, but you still need to work through the process to make sure. So, one concept under the ADA that is a good one to mention here because it's one of the few tools or concepts that really are beneficial on the employer's side. Under the ADA, an employer does not have to excuse essential functions of the job as an accommodation. So again, that's why you need your job description, right? Because if you don't have any way of knowing what the essential functions of the job are, that can be a problem. But say you have a job description, go back to that example I was just giving of the salesperson who's required to meet a certain quota every week. If that employee came to you and said they're not able to do it because of their mental health condition, the answer might be there is no reasonable accommodation, but it would still be a best practice to go through the process. Ask the employer, go through the steps that Doug talked about. Give the employee the reasonable accommodation letter, give the employee their essential functions to take to their healthcare provider, have the employee come back with the letter that tells you which functions are impacted and what the recommended accommodations are. So, very important that you don't just assume there is no accommodation.
So, Pam, that made me think about something else that we've seen a little bit of, which is I think occasionally employers will say, okay, well, everything in the job description is an essential function. Here we go off to the races. But that really what has to happen is the employer has to think about each one of those things that's listed in the job description and determine whether or not it's an essential function. I think just saying, it's an essential function that they be in the office every day from 9 to 5 without some reasons to back that up could potentially get employers into trouble. I was also thinking about something that Jennifer started to bring up, which is, and that you talked about as well, which is this sudden decrease in performance. Like, even without anything else, I think there's a pretty strong argument that can be made that puts employers on notice that something's going on, which maybe makes them think about ADA, and in particular about mental health, right? Especially if they know that there's been some changes in the employee's life, for instance, like family issues or something like that. So, yeah, just a couple things that I came to my mind.
Yep, I agree. Those are good points. Another thought that crossed my mind as Doug was talking is a scenario that I think is one of the most difficult ones for employers to work through, one where you would definitely want to call counsel, is when you have a situation where you have multiple disabilities involved, multiple medical conditions possibly covered by the ADA. And the scenario that comes to mind is someone who appears to be impaired in the workplace, appears to have or a drug or an alcohol issue, coupled with some type of comments or previous communications or discussion about depression. So, some type of depression, alcoholism, drug use, meaning like prescription drug use. We know that illegal drug use is not covered, but prescription drug use could be. Those are super complicated. I think the most difficult ones for employers to noodle through for sure. But you wouldn't want to make an assumption, hey, that looks like this employee's intoxicated. That clearly violates the policy. They're out the door. If you haven't thought through the ADA piece of it, for sure, just making sure it at least is flagged as a potential ADA issue and requires a little more time and attention.
I was going to toss on to that. Sometimes depending on the nature of, the employer's work, sometimes there are safety concerns at play. Those also tend to be more complicated cases. But I would say there's definitely a theme throughout a lot of these comments, which is don't make assumptions. The process is there for a reason, and well, many reasons, but one of the main reasons is that you are making decisions based on some level of information, and not just an assumption about what the employee can or cannot do, or how their particular condition does or does not affect them at work. Everything is really designed to, there's a process in place to, in an appropriate manner, be getting information. And I will say one of the things that I do see sometimes is employers really focusing on the condition itself, right? Like getting information about the condition, knowing how bad is it, how long is it going to last, things like that. And look, there may be some situations where duration could impact what is a reasonable accommodation. But generally speaking, that is not the kind of information that an employer wants or should be focused on. The question really is, whatever the condition may be, how is it impacting this person at work? How is it impacting their essential functions? Is it impacting their essential functions? And if it is, what are some options for, like, what do they need, right, to remain in the workplace and do their job? And is whatever they need something you as the employer can give them?
So that's interesting in talking about information, right? Because importantly, the information the employer has is basically what the employee does at work and what the employee chooses to share with the employer. Doing your own research and going and finding out about somebody's medical condition is neither of those. So try to focus on what the employer has what the employee has told you in their words and in their actions.
Yeah, that employers run into trouble with that a little bit because a lot of people have personally had their own experience related to depression or maybe anxiety. Maybe it's something you experience. Maybe it's something a spouse or a child or a sister or a brother experienced. And employers get into trouble when they start using their own personal experience as a basis to consider accommodations. I mean, you don't want to do that. Even with the mental health issues, you still want to get the healthcare provider info. Avoid stereotypes. Again, the ability to get info from a healthcare provider is one of the few things that the ADA really does give to the employer as a tool to analyze accommodations. Make sure you use that one. I just thought of another good example of something we've seen multiple lawsuits arise from when it comes to mental health disabilities in the workplace. And that involves another really difficult issue for employers, which is the intersection of FMLA and ADA. So we know that under the FMLA, if you had, like, say, for example, you had an extreme mental health condition that required inpatient treatment, for example. So you applied for and received FMLA in order to go get some type of treatment. Maybe it's mental health treatment, maybe it's alcohol recovery, maybe it's some type of prescription drug addiction treatment. If you apply for that and have some type of conversation, the employer has some type of conversation with the employee about it, and the employer knows there's a mental health condition at issue, when the FMLA leave expires, is there an obligation on the part of the employer to then engage in the ADA process when the employee returns? I would say that is an issue that is often overlooked by employers, that issue of what happens when FMLA is done and the employer returns to the workplace. Don't forget to consider whether or not you need to engage in the ADA process for that one. I would argue that it's not a bad idea. Even if you're just giving the employee that reasonable accommodation letter, If the employee doesn't want to return it, they don't have to, but you can show then, we recognize this. We did what we needed to do to see if there was anything else, and it didn't go anywhere.
I had one other thought that it is switching gears a little bit, but this idea of temporary accommodations while you're kind of working through the interactive process is what we call this whole process, right? Of asking the employee to have their healthcare provider, get information about, what essential functions are impacted and how, and what accommodations would help. I would say, it is not that uncommon for employers who are, they're good employers, they want to help their people, to just say, well, while we're working through this, we're going to let you do X, Y, or Z. And maybe the employee then gets used to that just being the new normal. And then after going through the process, as it turns out, the accommodation is something else other than what you've been doing for the employee for this period of time. And if the employer hasn't documented that that was temporary, we're not promising this to you for forever, that could lead to problems. And I think where this can come up a lot is often if you have supervisors who, kind of either adjust schedules or let someone work at home. These are just sort of, examples, but, give the employee something like that, but don't make clear that it's not for forever necessarily. It can sometimes create problems and difficulties down the road. So we always recommend, sometimes a temporary accommodation is appropriate and it makes sense and it's a very good thing to do, but to actually think through that, what does make sense for the temporary accommodation? Is it some kind of hardship? And then making sure it's documented in a way where it's like, hi, we're going to do this for you for now, but, it could change, and just making sure the employee is aware of that. And I think A, that's just a good thing from, a potential liability perspective, but B, just more practically, that way the employee isn't surprised, right, down the road. Everyone's been transparent, it's been clearly communicated, and everyone's just aware of what's actually happening. I think is just helpful from a practical perspective.
Yeah, that's a good reminder. All things ADA, you got to document it, right? You open the file, you're documenting what info comes in, the conversations you're having. Jennifer's point is a really good one. Anytime it's temporary, make sure you've got that in writing so that it's not misunderstood as being a move to a different position. So great point. So that's it for today. Just a reminder that disability discrimination claims, they are the #1 source of lawsuits against employers in Idaho and everywhere around the country, because this issue is somewhat difficult to know and maneuver through. This issue is part of the reason we wrote our book, Law for Leaders, the roadmap every leader needs to know to avoid workplace claims and lawsuits. We have 3 chapters in there on the ADA, one about the scope and 3 basic ADA concepts, one about alcoholism and drug addiction, and one about mental health and complex issues like suicide. We didn't get to the suicide issue, another very complex, scary position for employers to be in. But check out our book. It's on Amazon. That is one very easy way that you have a resource on demand and available if a problem comes up in the workplace. I think the odds of you having a mental health issue in the workplace, probably pretty high. There's so many people touched by some type of mental health condition. So keep that in mind. Don't forget, we've got our Law for Leaders training. If you're listening to this thinking there's no way my supervisors know that, and that's a huge problem for us, call us. We have virtual content. We have content virtual recorded on the ADA, and we do in-person training too. So if there's something you need trained on in person, we would love to do it. That's our favorite stuff, is helping keep employers out of the courthouse. So keep that in mind too. Otherwise, that's it for today on Ground Rules. We'll see you next time.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.